I would like to entice you with a strange hypothetical. It is the situation that Mr. Darrell Brooks finds himself right now. If for some reason you were forced to run your own trial, would you have any idea what to do? Now, I can only explain trial procedure here in my country of Australia, and really only in my state of New South Wales. But if through the cruel hand of fate, misfortune, bad luck, etc., I was forced to run my own hearing, I would do the following. The first thing I would do is I would find the charge. Let's begin with an easy offense that happens pretty much every day here in Australia: common assault. First thing you do is you pull up the legislation and you go through the elements. Whosoever assaults any person, although not occasioning actual bodily harm, shall be liable to imprisonment for 2 years. So 1, whosoever, it has to be a human. 2, assaults any person. What is an assault? We're going to look at. And 3, although not occasioning actual bodily harm. The 4th is the punishment, up to 2. So then I'd go and research. What does it mean to assault someone? You can do this by checking out a note up or looking at the relevant case, or going to one of the hundreds of helpful guides that are available online that explain how to read. Then, what is actual bodily harm? I know from my experience it's more than transient and trivial, but you can read up on what it is. So now I understand what the prosecution has to prove. And if they fail to meet any of those, I win. But I'm not done there. So now I have more questions than I have answers. So what do? You go to the bench. What's the bench book, Jahan? The bench book is the book that members of the judiciary use when they look at certain charges. Here it has the definition. For example, it must be an act, not a mere omission or act. It has to be intentional or reckless, and it has to cause another person to apprehend immediate and unlawful. I then go through the bench book and read the cases that it cites, because they would tell me what I needed to know and didn't. Now, having understood what the charge is, understanding what the challenge is, I then have to understand the different voir dires or procedural steps. But there's a procedural bench book for that. And in New South Wales, we have an Evidence Act. The Evidence Act tells us how evidence does and does not get it. And with a few hours of practice and study, you'd have some understanding of it. Now, would you ever be able to do as good a job as a qualified advocate? Of course not. But could you get sufficient understanding to bumble your way through something resembling a trial? Well, yes. And that's the thing that people need to understand about why people are allowed to represent themselves. It is difficult and practically impossible, but an individual can, not saying they should, but can get to the stage where they can run something resembling a legal argument in front of a judge. And most judges will assist people and give them the benefit of the doubt and help. Just look at the judge in this case relating to Darrell Brooks and how patient she's been and how respectful she's been. And that might include interpreting procedural steps in such a way as to benefit. The people commenting that his case is impossible and is an impossible situation, with the greatest of respect, he has made the situation himself. He turned down legal advice. He's decided to run the case entirely like a fool. And he's going to get what's coming.